Good afternoon.
Good afternoon.
It's evening is
Good
evening. It's
afternoon.
after
Good
6.
evening.
I keep saying afternoon and it's evening. How's everyone?
Good evening. Fine.
Okay.
Oh Lord, you all sound so dry. I don't know why. Why you went so quiet? Okay, so I had a chance to look at the homeworks. Shanique, I see yours just came in. I'm looking at it now. I see you being very kind to him. Okay, so that don't align. Okay, Shanique, let me start with you there.
Again?
Well, you're the last one to send in.
Oh,
So
Lord. Okay.
it doesn't matter. There are others. So worry not. We'll get to the chapter.
Okay.
All right. Everybody remembers the question, right? But Shanique, you just send yours, so you know very well. What were the issues, according to you? What were you trying to answer based on the facts?
Well, the fact that he was managing his account unsatisfactory.
Okay, hold on. Write that down. Jot a note. Everybody jot a note down. I'm jotting it down too. First issue was managing his account unsatisfactorily. What's the next one?
That he was I guess this goes with managing the account unsatisfactory. The fact that he was writing checks, knowing that he didn't have the funds on the account to like
So
cover
same
the
thing.
checks.
Same thing.
Okay. And then the next issue would have been that he would have placed a stop on a check, but
You have to talk
the
about.
stop was overlooked by the bank.
Okay, so put placement of stop payment. That's the second issue. And third one.
Would have been that it cost him to have a bad credit, I guess, but whoever he was trying to pay.
Okay, so then he wants to a complaint. Let's say he did a complaint, right?
Yeah, yes.
For damages to his reputation. So everybody agree those are the three main things?
Yes,
Okay, no one has anything different, right? Speak up. Everybody agrees that's the three things that we should be addressing. Okay, so let's go then, Shanique. So I noticed everybody did the same thing, and that must be the notes. First, they said that it was a debtor-credit relationship. Some people put in fully versus ill, some left it out. So if this was in the exam, those who put it in would get an extra 1 point. Okay, then you say, he is conducting the account in an unsatisfactory manner. He's writing and issuing checks when he doesn't have funds. Placing stops on checks, okay. Then you say, I would firstly advise him of the misuse of his account. Refer him to the terms and condition. And then would you say, I'd also make him aware of the penalties associated with conducting the account unsatisfactory. I don't understand what you mean by penalty. But you be talking about the fees, the charges? Because he should be aware of that. He has a pattern. So he does this all the time.
I mean, when I said penalties, I stated the penalty fee is for, I guess, for every time he wants to stop a check or like just conducting the account unsatisfactory on the whole. And
Okay.
then I also stated even by us, a penalty could be us terminating the relationship because he does have a agreement with us to conduct the account satisfactory. So in a
Okay.
case like that, we could even terminate the relationship with him.
I agree with you. I agree with you. Now, what missing out of your first paragraph is you need to speak to his duty and the bank's duty. Because you alluded to it when you speak about the terms and condition agreement, acknowledging that he would have acknowledged when he opened the account. But those terms and condition, you're speaking to specific duties that he would have agreed to, and in relation to the duty that the bank would have given. So in there, you are missing your duties. Then you say, as it relates to the return check, you said the bank would apologize. Quite a few people have that in theirs. That's fine. You would apologize because yes, instructions was given. I don't understand why it would be a reputation on the bank. And a few people have that in theirs. Why would this be a reputation on the bank? A risk to the bank?
I mean, because as the bank, we do have the obligation to our customers to do it right the first time. So in a case like this, even though his behavior is like, this is something he always do and it's not a good behavior, he still did what he was supposed to do, which is place a stop on the check because he didn't want the check to be paid out. But we, as the bank, when the customer, whoever came in, who we paid the check to, we didn't do our due. We didn't go in and check to see if any stops were on the check or whatever. We just processed the check, sent it through, and then it caused it to return on his account. So that he could actually fight that. Just, you understand? So that is like almost like a reputation thing because it could be like, y'all don't be doing what y'all supposed to be doing in a way.
What is his reputation?
No, I mean the reputation of the bank. I wasn't meaning on his end.
But I'm saying now, if you're gonna argue on that ground, then you have to look at what would his reputation be out there if every time he writes a check, he puts a stop on it. What kind of reputation does he have out there?
I mean, I wouldn't say a good one.
Not a good, exactly.
No.
It's not a good one. So you got to look at it from both sides. Like let's say if this was a customer who had put a stop, the bank didn't action it, but he is a customer in good standing. Yes, then you could say the reputation of the bank would be at stake. But he's going to say like, I sent instructions, the bank didn't do it. This is going to really damage me. But this man doesn't have a good reputation at all out there, nor within the bank. So like a lot of people agreed, you just apologize to him. You could reimburse him the fees. But then like you said at the very beginning, one of the penalty is, and based upon his pattern or the way in which he operates the account, it's a good time now to terminate the relationship. Because like some said in their papers, it's kiting. And there are a lot of behemoths that do that. Nadia, I'm looking at yours. That was good, Shanique. Nadia, okay, I'm looking at yours. Yours was fine. You put your cases in, you left out Foley versus Hill, but you did put in your case regarding the duties of the bank and the customer. And then you did put in your case on the Westminster versus Hilton, which was good. And at the end, you concluded that the bank should not be liable. Because of course he has a patent. So yours was done well too. Sydney? Sydney on? Yeah, Sydney is on. Okay. I see you put in your Foley versus Hill. Let me see. You put in your Curtis versus London City. And at your issue, you talk about kiting, which is what he was doing. Then you say, as a result of the bank's negligence in following procedures, the check has been returned, affecting the client's financial position. I mean, you could say that, but like I say, his reputation is already ruined.
Yes, ma'am.
Yeah. So just when you read the scenario, think about it from both sides, from the banking side and then also from the client side. Of course, the client always wants to sue. And I see where you put it in that, yes, terminate the account. Now, your sentence, but offering him an overdraft facility, the answer to that would be no. From a risk perspective, no. Because he has a patent and he's not a good customer. He's not operating his account in the right way. Why would you want to offer him an overdraft facility? Tell me.
I mean, when I say offering them an overdraft, I mean in terms of saying that it may be where he has a lack of funds, and it isn't that he wants to, kite, but because of his situation.
Go
But
back,
like you,
step back, step back, step back. Think about that now. He's kiting. You really think the bank will take the risk for someone who is kiting to give him an overdraft facility? An overdraft facility is a loan. Is that really going to help him?
I think so.
Okay, because I've seen instances where they were kiting, and just like you saying, the credit department approved loans, and what happened? That balance off for a week or two, and then they're right back to kiting because they can't manage money. It won't work. Roma, you have your document in front of you?
Yes, ma'am.
Okay. Your very first paragraph is too soon. That's what I wrote on the side. Remember what I, right. You have to look at what are the issues. And we started off by saying, what are the three issues? So the first thing you're going to talk about is what you have in the second paragraph.
Okay.
Okay. And then after you finish talking about what's in the second paragraph, when you're supposed to be talking about how he is managing the account, then you need to talk about the placement of the stop payment. And then you look at the referral borrow. So what you wrote wasn't bad, but you need to put it in order. And that's why I say until you get the art of knowing what the questions are out of your head, you can write them on the paper. These are the three questions that I'm answering. And it'll make it easier for you so you don't lose points.
Okay, yes, ma'am.
Okay. My good friend, Ellen. I'm so happy that you did 1, 2, 3, 4 questions. Is Ellen on tonight?
Yes.
Okay, so why are you being quiet? You did 4 questions. And thank God you did 4 because 1 is not right.
Okay.
Because you made the statement that the stop has been overlooked, but then you asked the question in reverse. You notice that on your paper?
Okay.
You say the bank overlooked the stop, but then you
Mhm.
turn around and say the bank put the stop on the check. No.
Yeah, yes, yes. Sorry, yes, I saw it afterwards.
Okay. Okay.
Yes, ma'am.
Okay. So I see you put in your case Foley versus Hill, Curtis, Westminster, you have Joachimson, and you have Prosperity. And that was very well done.
Thank you.
See my Rowan, it helps.
Yes.
The Taylor is on. Taylor, I can leave you for last. Yeah, I can leave Taylor for last. Let me see if he's on. Martin isn't on. Robert? No. But it yeah. Charlton? Yes, she's on. Charlton, my you have your cases in here. Please don't put, if you were to write this in an exam, don't write all this in one paragraph.
Okay,
Same way,
understandable.
right, the same way we said there are 3 issues,
Uh-huh.
you should 3 to 4 paragraphs. Your last one will be your conclusion.
Okay,
And everybody, your conclusion is normally only 1 to 2, maximum 3 sentences, which would be, I would recommend that the bank terminate this relationship. Or like some people wrote in their paper, I would recommend that we continue to keep a close eye on this relationship. And if it continues in this manner, maybe over 3 months or 6 months, terminate this relationship. That's your
Right.
conclusion. But don't run all of this into one, because then I have to then decipher when you're starting the second issue and when you're starting the third issue.
Yeah.
So let me see what I wrote on the side here. Something here. You say going down almost 3/4. You say, as a customer, Mr. Williams has a responsibility to follow our policy, because when he entered a relationship with the bank, he agreed to follow our rules and regulation. That's a very general sentence. What you need to do at the very beginning, right after you finish your Foley versus Hill, and you speak about the bank's policies and procedures, then, like I said earlier, you need to state what was his duty as a customer and what was the bank's duty. Because once you establish that, then you can say, in accordance with the account opening documentation that he would have signed, he had a responsibility to follow the bank's mandate.
okay,
Okay, so don't make the general statement.
okay,
Okay, so you have here that when he entered into, this is what he agreed to, then you put the case of London versus Macmillan, which is good. But you need to set out what the duties are on both sides.
okay.
Okay, and other than that, it was very good.
Thank you.
Okay, now I have Capron.
Hi there.
All right, so my dear Capron, why is this so short?
Yeah, I realized after you discussed those, I probably missed out my cases.
Yes. I mean, what you've written, nothing wrong with what you wrote. But then, like I say, there's a way in which to answer. So you have to answer the 3 questions that you have come up with. And in this one, it was a simple 3 question. Because in here, you more or less insinuating that the bank has already closed the account.
Okay.
Yeah, in your second paragraph, which the bank hasn't done.
Okay.
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 And then in the third paragraph, yes, you can apologize, but it won't be for his credit. You're really apologizing for not following his
Oh, record system, sorry. Well, yeah, okay.
and then you have here that you won't continue to do business with him, and then you gave the reason why. So you more or less have the essence. You understand what the question was about, but you need to lay it out properly,
Got it.
okay? Because you have the comment on the way in which he is operating the account. What does it mean? So you can come to your conclusion that either you're going to continue monitoring it for a time period or you're just going to close it.
Yes, ma'am.
Okay. So the next one is Taylor. Okay, Taylor, I read yours. You left out Foley versus Hill. On the second page, on the review of Mr. Alvin's Williams account, go down in that section almost just past the middle, where you said, in findings of Mr. Williams' habits, he should be advised that drawing checks when there are not accurate funds on his account is risky and dishonest. I don't know why you put the word risky. Why don't you just simply say to him, it's a breach of the bank's policy and the mandate that he signed. Don't say risky. Is it risky for who? It's not risky for him. It's a risk to the bank. But his actions is a breach of the bank's policy and the mandate that he signed. I like how you laid out your processes, which made it quite clear. And I like how you put in the cases like everyone else, the London Stock Bank and Macmillan. And then you close out by saying the warning letters can also be said to provide the customer with sufficient notice before the closure of the account. Because you say, give him notice that you're going to close the account. And you refer to the case of Maurice versus Scotiabank. So do you want to tell the class a little bit, summarize that case? Did anyone read it? Other than Taylor?
I read it.
Okay, because Taylor put this case here, and if he can show me, not just by tacking it on, but if he can demonstrate how it is relevant to this, then he gets an extra 5 points. Because it's a local Bahamian case. All right, so let's go. Briefly tell us what the case was about, because everybody needs to read it.
Basically, Maurice Lincoln, who was the plaintiff, sued Scotiabank in the reason of them closing her account. In her defense, she stated that, pardon?
His,
Pardon?
Maurice is a man.
Oh, it's a man. Okay, sorry. Yeah. So in his defense, he stated that he would have opened his account in the early parts of 2000, the year 2000, and I guess I'm assuming he was not a local.
Yes, he's a Bahamian.
Okay, he's a Bahamian. Okay, so it also stated that he failed to, or his law firm, to be exact, failed to provide the bank with a copy of his central bank permit to hold a U.S. account, a U.S. dollar account, and I guess Scotiabank later renewed the account some 15, 16 years later, if I remember, I'm reading, and then he would have met with the manager of whichever branch his account was held at. Scotiabank's defense, they tried to justify their reason for closing the account as they stated Mr. Clinton would have failed to respond to some information, I guess they were requesting from him to update his KYC information. And I guess because of his lack of response, according to them, it resulted in them closing his account. But I guess in the end, with the findings from both parties, the court awarded Mr. Clinton. He won that case against Scotiabank. I guess ultimately because, you know, like I would have closed off my assignment, the bank didn't give him, I guess, proper notice.
Yeah.
That they were going to, you know, discontinue or terminate business with him. And so, you know, that can cause, I guess it can damage his I'd say reputation at that point, and it could also be a huge inconvenience, especially you know if he operated the account like an everyday account and for businesses. So because of Scotiabank's lack of what's the word I want to use? Lack of informing Mr. Clinton.
They didn't give reasonable notice.
Right, they didn't give him reasonable notice. So that in turn, that's a breach in the contract, because it I guess now it would say, you know, that we have to properly, I guess, inform our customers and clients, be transparent with them in you know the actions that we take against the account, because it can cause some damage to the customer.
You have to give reasonable notice, and reasonableness depends upon the nature of the account.
Right.
So he was a law firm, so you couldn't just close his account. Let's say if it was a business, a grocery business, you can't just give them 3 months, because it depends on their outlay. They may have contractual agreements that come around in 6 months or 5 months. So you can't just automatically just close it. You have to look at the nature of the business. And that's what's key when you say use that word reasonableness. Reasonableness is based upon the nature of the account. So for those who haven't read it, you can read it and you'll see some of the cases I mentioned right in this Maurice Clinton case. You have Joachimson versus Swiss, you have Prosperity, and of course now you have the Bahamian case of Maurice Clinton. So the case isn't that long. There's only what? 30 paragraphs. 1, 2, 3.
Roughly 12 pages, I think.
7, 8, 9, 10, 11. Yeah, only 12 pages. So it's a very short read. And you'll understand what reasonableness means. And giving adequate notice to your clients. Any comments?
There's actually 5 points for that explanation.
Oh, Maurice? On the Maurice case?
Yes, ma'am.
Oh, yes, he will. He didn't just write it down. He actually read it. He went the extra mile. He's the only person who put that in there. And that's what I look for when you write your exam questions, to see if you've been doing any reading. I don't expect you to go all over the place, but I have given you Bahamian cases. And then I promise you all, I'm going to send a few more. Remember last class? but I didn't want to bombard you with too much things at one time. So now everybody got a chance to read chapter 5 on the duty of confidentiality. Yes?
To be honest, Ms. Archer, I think we are all caught up with trying to complete the assignment and trying to
Come on.
review the case laws for chapter 4 still. I'm the one that you to send you an email.
Is that an excuse?
No, but it's a valid explanation. I wouldn't call it an excuse.
Okay. All right. I hear you all. I do have 3 cases to send you all this week. 3 more. 3 more Bahamian cases. Well, yeah, 3 more Bahamian cases. 2 from the Supreme Court and 1 from the Privy Council. So let's talk about this duty of confidentiality. Since you didn't read the chapter, did anyone read section 77 of the Banks and Trust Companies Regulations Act? Okay, silence means no. Did
Yes.
anybody read? Who said yes? Ellen?
Yes.
Okay, very good.
For some
Um,
reason, I
uh-huh.
had section 7. I had section 7. I don't know why. So I read section 7 instead of section 77.
Oh, you left off a piece of section
Yeah.
77. And then I also told you all to have a look at the Data Protection Act. I hear quietness. What does that mean? Yes?
I skimmed through.
Okay, well, skimming is good. I mean, you have this week to go further.
Yeah.
All right, so let's start with the act. And then, like I said, I am going to expand on the notes. So Ellen, since you read it, I'm sure there's someone else just being shy. Tell us what section 77 says under the preservation of confidentiality. In the repealed Banks and Trust Companies Regulation Act, that section was called the duty of confidentiality, and was called that because what the Bahamas did is it enshrined in law the duty of confidentiality that was taken from the case of Turnier versus Provincial. So now in the new Act 2020, the section is now called preservation of confidentiality instead of duty. So tell us about this section, Ellen.
Basically, in this section, they're telling you nobody without the proper express or consent of the customer concerned shall disclose information relating to their identities, assets, liabilities, transactions, or accounts of a customer of a licensee. And it name, or in section 77, it name all those persons in A, B, C, D, E, and F.
Mm-hmm.
They talk about the director, officer, employees, or agents of a licensee or former licensee, counsels and attorneys, consultants or auditors of the bank, or employees or agents of such counsel and attorney, consultation or auditors. And then they talk about counsel and attorney, consultants and auditors. Sorry. Sorry about that. And then they talk about auditors and auditors of any customer or any licensee or former licensee or an employee of or agent of such auditors, like, you know, when we have auditors come in, all those persons, right? And then they talk about the inspector under the provisions of this act, and the supervisory authority or director, officer, employee of an agent or supervisory authority shall, without the express implied consent of the customer concerned, disclose to any person any such information relating to the identity, assets, liabilities, transactions of accounts of a customer or licensee, or relating to any application by any person under the provisions of this act, as the case may be, except for the purpose of performance of their duties or the exercise of their function under the act, or for the purpose of performance of the duties within the scope of their employment, or when a licensee is lawfully required to make disclosure by any court or competent jurisdiction within the Bahamas or under the provisions of any law. There you go, or any law. The supervisory authority, which is responsible for the regulating of the head office of the licensee for the purpose of consolidated supervision of the licensee by the supervisory authority. Want me to go on?
What else? It talks about a lot of other stuff.
For the 77. I'm missing a
77.
page.
Go ahead. No.
Okay,
You look- don't
yeah,
look
I'm
at
missing a
the
page, right. And then for the purpose of enabling, assisting the bank to exercise any functions conferred upon the bank by any written law. In the case of bridge institution, to the minister of his designate. In the case of an asset management vehicle, to the minister of his designate, to a person within the view of the institution, or for the purpose of criminal proceedings, disciplinary proceedings within the Bahamas or outside of Bahamas relating to the exercise of a counsel, an attorney, auditor, accountant, values, or actuary of his professional duties. The disciplinary proceedings relating to the discharge by a public officer or member or employee of the bank of his duties.
Okay, so when you look at the section you just read, the subsection F, subsection 1 through
Right.
7, they
Right.
said as the case may be except
Except
for.
for the, right,
So section 1, A through F speaks about what you cannot do. And then it says, except you're doing these things in the performance of your duties or within the scope of your employment.
right,
If the licensee is required to give some disclosure to the court, or the bank is trying to assist in exercising some function or giving information to the minister, or let's say in the instance where the banks would have sold those assets to vehicles. Remember the delinquent loans, and they sold them to vehicles, right? They can disclose information. And of course, if they're criminal proceedings, whether it's within the jurisdiction or outside the jurisdiction. Then section
Then
2 says what?
they could provide information to like other branches, head office,
Mm-hmm.
as the
But it must
inspector may
be-
determine.
hold on. There's a
Pardon me?
caveat to that. Hold on, there's a caveat to that. They can only provide that information for what purpose? For the purposes of carrying out.
Carrying out collation, yeah, synthesis or processing of information on behalf of the licensee.
Exactly. So when they say they're doing consolidated supervision of all of its branches and all of its subsidiaries around the world, those balances go up, but not the names of the client. Okay, what section 3 says?
For any civil proceedings where information is likely to be disclosed in relation to a customer's bank account, those proceedings to be held, the court could hold them privately
Mm-hmm. So they are
Mm.
actually heard in chambers.
Right, and the information shall be held confidential between the court and the parties there.
Right. So not every matter that is heard by the courts are published on the website.
Right.
Go ahead. Section 4.
And then no person shall publish the name, address, or photograph of any parties in those civil proceedings. As
Mhm.
referred to in subsection 3, and information likely to lead to the identification of the parties either during the currency of that proceeding or after they have been terminated.
Right. So you can't take any photos.
So
Five.
what about when they have when they talk about cases going on in court, sometimes they be like financial and
talking-
and
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 people-
when and people on their way to court and they take those pictures.
You're talking about when they are charged with money laundering?
Money laundering or any.
Mhm.
So what about those when they take when they take those pictures on their way to court? Would that
Then
be considered an
that-
offense?
That's a crime. That's going under the Proceeds of Crime Act.
Okay,
That's not coming under the Banks and Trust Companies Regulations Act.
okay,
That's criminal matter.
okay. That was funny. Okay, and then 5, the bank may subject to the revision of sections 32(2), provide information on the beneficial owners, directors, officers, and operations of a licensee, including any reports produced by the inspector.
Mhm. And section 32, subsection 2 speaks to
Subsection 32 speaks.
32, subsection 2.
I don't have the whole act with me.
Okay, so 32 subsections 2 says any branch or subsidiary of a bank or trust company to which subsection 1 applies, and subsection 1 speaks to inspection by a supervisory authority,
Mhm.
subject to the conditions set out, permit the supervisory authority at all reasonable times to conduct its inspection. And as long as they have obtained the prior approval of the inspector. And they have to give the inspector a written undertaking to comply with our legislation. They can only use the information exclusively for the purposes, again, of consolidated supervision. And it can't transmit information obtained during the course of its inspection to any other authorities or bodies without the written consent of the inspector. So again, the supervisory authority can come into the Bahamas, not just to get information for consolidated supervision, but they can get information on the ultimate beneficial owners, directors and officers of a licensee. It ain't finished yet. Let's go.
Okay.
Section 6.
Section 6, to facilitate regulatory cooperation within the Bahamas, the governor or any director, officer, employee, agent, or advisor of the bank may cooperate with any other domestic regulatory authority, including by sharing information on the beneficial owners, directors, officers, and operations of a licensee and any of its affiliates, or any other information acquired by the discharge of functions and duties under this or any other act, where the Governor General considers that such cooperation or information may be relevant to the functions of such or other regulatory authority, or as necessary part of framework for consolidated supervision, oversight, or regulation of the financial services sector.
Okay, everybody understand what that means?
Part of it.
Hmm?
I'm gonna go back over that.
No, but you have colleagues on. Everybody understand what that means? Maki?
A portion of it I understand.
Okay, tell me the portion.
Portion of it. The part, let me look over it again, because that was a thought. The part of it I understand. So incorporate requirements. And incorporate. I try to read over it again real quick.
Mhm.
Then you have the domestic regulatory authority included. Issuing information on the beneficial owner, director, or officer and operations of a license and any of its affiliates. So basically, from this standpoint, basically it's saying that they have authority to share each other information.
Mhm.
That would be only based on everyone, which is owners, directors, or any officers in operation of the license.
But it goes further.
Discharge function and duties under this act where the governor considers that such cooperation of information may be relevant to the function that such cooperation or information may be relevant to the function of that such cooperation or information may be.
Yeah, you reading it twice.
Yeah, I see that. On a regulatory authority or
Right.
as a necessary part of the framework.
Mhm.
That part of it I don't really get.
So that
Okay.
give us,
Okay.
so that's the part would give us, give all the banks the authority to like get information from each other.
Well,
Is
in
that
terms
it?
of what information, because I know you can't get all information,
No,
but
but
Is it,
only necessary
only,
information
yes,
pertaining to the case.
And information
right,
relevant.
and then it ain't gonna be, it wouldn't be all information, because you have certain people who the directors and
Yeah, but
the,
this last part doesn't speak to that. This last part that he just read, it speaks to all of the regulators meeting together to
Mhm.
ensure that the framework that governs all of the regulatory bodies is on one accord.
Okay.
So you notice recently when they released new guidelines, they do it as one body. They'll say these guidelines are from the Central Bank Securities Commission, the Gaming Commission, and they put Insurance Commission. They all come together, and that's what it's talking about. It's a cooperation between all the regulatory body to make sure that they speak from one hymn sheet on certain matters.
Mhm. Put a note on the side.
Okay, section 7.
Nothing contained in this section shall prejudice or derogate from the rights and duties subsisting at the common law between the licensee and its customer.
What that means. It don't have to be Ellen. Ellen is doing the reading. What does that mean? What's the 7A means?
Does it mean that we can't like not, I guess, and let's say for example, on board or serve a customer or disclose information to a customer because of who they are, like not being equal with each customer or something to that extent?
I understand what you mean. Give me an example.
Okay, let's say for example, a customer were to come into the branch and, you know, based on how they look, we deny them service based on that or something to that extent.
Partly. Anybody else want to try?
Nothing in the session would prejudice or take away from the rights between, would it be between the banks and its customers?
Mm-hmm. So what does it tell? It's telling you in 7A that from
I
7.1
think
7.1 all the way to 7.6, all of these things is telling you that the inspector can do, that you cannot do, that the other regulatory bodies can do, that a supervisory authority from overseas can do. They're telling you no matter all of those things from 1 through 6, that common law, Johansson versus Swiss, and the other cases that lists out the rights and the duties of a customer and the bank, those things don't supersede that.
Okay.
The rights and the duties of the banks and the customers, those are paramount to the banker-customer relationship. That's A. B now.
Prevent a licensee from providing upon a legitimate business request in the normal course of business a general credit rating with respect to a customer.
What does that mean?
Nothing nothing should stop. It shouldn't prevent a licensee from providing legitimate business or information requests from other businesses.
No, from a customer.
From customer, with respect to customer.
And in particular, it's credit rating. Because remember, you have the credit,
Yes, the credit rating.
agency
Credit
now.
bureau, yeah.
Right. It says, as long as it's done during the normal course of business, you have no right to deny that person their request. You can't say, I'm busy because we're in an inspection. Oh, we're busy because we're dealing with this. Oh, we're busy because we have these requirements from our head office. It says you can't deny a person their legitimate right. What's C?
And C, you cannot prevent the inspector from sharing information relating to the identity, asset, liabilities, transactions, or accounts of a customer of a licensee with the Financial Intelligence Unit, where he believes that a suspicious transaction was not reported as required under the Financial Transaction Reporting Act 2018.
And what that means? Anybody? Russell, what does that mean?
It's pretty much saying that all of this information, like you said, we read from 1 to 6, that shouldn't prevent us from sharing information with the Financial Intelligence Unit. Like, for example, if a customer is money laundering or they are providing funds to financial terrorism or anything like that, that shouldn't prevent us from providing that information. Or if the customer, because it says
Yes.
the specific transactions. Yeah, that.
Yeah, and that you should file if necessary. All right, let's go. Section 8.
The bank in the exercise of its corporation functions may, with the approval of the governor, enter into memorandum of understanding with supervisory authorities for the purpose of facilitating the consolidated supervision of its licensees.
Okay, so all that simply means is that if you're a bank here, licensed in the Bahamas, and your parent company is from Brazil, and your supervisory authority is the Central Bank of Brazil, then what they will do is they will do a memorandum of understanding and agreement between both regulatory bodies. That if we were to come in, this is what we expect. And then Central Bank will say, if you come here, this is what we will expect. And if they intend to exchange information, all of that is in the memorandum of understanding. So it's just an agreement between the two regulatory bodies as to what each may ask for in terms of making sure the consolidated supervision is done properly. 9,
No memorandum of understanding entered into. Okay, let's use this copy good.
pursuant
Entered
to,
into
pursuant to subsection 8.
Okay, subsection 8 may call for assistance beyond that which is provided for by this act, or relieve the bank of any of its functions or duties under this act.
Okay, so what that section is saying is that the memorandum of understanding cannot go beyond this section. So that means that you cannot come and say you want to, as a supervisory authority, you can't state in your memorandum and understanding that you want to see the name of the clients, because that's in breach of section 77. And 10,
And every person who contravenes the provisions of a subsection 1 shall be guilty of an offense and shall be lied on summary conviction to a fine not exceeding $25,000 or to a term of imprisonment not exceeding 2 years, or to both such fine and imprisonment.
yes. And that's section 77,
The penalty.
preservation of confidentiality. Anybody have any questions on it? Now, who did the Data Protection Act? If no one did it, I'm gonna leave it until next week. Anyone did it? Anyone read it? I hear a little voice whispering.
Maki, I have a question. Where were they reading from? Is this in the textbook or they were reading the actual act?
Reading the actual act, which I sent.
Right, I don't have that, so I
What you mean?
couldn't follow it. No,
What you
ma'am.
mean? You didn't get it in the email?
No, ma'am, I still haven't gotten any emails.
What is this again? All right. What's your email is again?
VincentMaki2@gmail.com. I haven't gotten the email. I think he was telling Ellen to send me an email as well. I haven't gotten that as well.
Ellen,
Me?
try and send her that email now with the act. Let me know. Vincent Maki2 at, what'd you say? Gmail?
Gmail.com, yeah.
Try and send it now, Ellen.
Let me see.
Vincent Maki2 at gmail.com.
Okay, let me send that.
Send it and then Vincent could tell us when he receives it.
Okay.
Did you get a bounce back, a failure message?
You're looking for where we send that. Remember when we send that?
Oh,
When we got that? Let me see.
2 weeks ago.
Oh, I have it. I can forward it to him.
I
Okay.
can find it.
Call them vincentmaki2 at gmail.com. And if you have the cases handy, send him the cases too.
When that was, we sent that one.
No, no, I don't know.
Everybody could, I can send it to see if he can still get it.
Yeah, still send it to see if he got it.
Okay, let me send these, see if it, Maurice Clinton.
And then remember I sent the 2 Makushla cases.
Right, I can send them right now.
That was, and then this week I'm gonna send you all 3 more cases. So I can start. So you realize now that the contract between the banker and customer is a confidential one. And the confidential nature of the banker-customer contract, it stems from the fact that it is based on the elements of an agency relationship. So as a general rule, an agent owes a duty of loyalty and confidentiality to his principal. And the scope of that duty will alter according to the type of agency involved.
Ms. Officer, sorry to disturb, but where are we exactly?
Hmm?
Where are we now?
I'm elaborating on chapter 5.
Oh, okay, okay.
Okay, that's why I said you can make notes of things that you want, that you don't think you remember. So the first thing is the nature of the banker-customer contract that comes from the elements of what we call an agency relationship. Because the bank acts as an agent of its customer. So as a general rule, an agent owes a duty of loyalty and confidentiality to its principal. So again, you're beginning to see that once you enter into a banker-customer relationship, you then have that agent-principal contract arising, and with that comes a duty of loyalty and confidentiality. So the connection between a bank's duty of confidentiality on one hand and the types of agency relationship was emphasized in the case of Parry Jones versus Law Society. And in that case, the judge, Lord Justice Diplock, said, such a duty of secrecy exists not only between an attorney and his client, but for example, between a banker and customer, doctor and patient, and accountant and client. Such a duty of confidence is subject to and overridden by the duty of any party to that contract to comply with the law of the land. If it is the duty of such a party to a contract to disclose in defined circumstances confidential information, then he must do so. And any express contract to the contrary would be illegal and void. And this case of Parry Jones versus Law Society, that was ruled in 1969.
We reading from the, you reading from the manual?
No,
Oh, okay.
remember, that's why I said you must read the manual. You'll see
Right.
a case of Parry versus Jones is on page 46.
Okay.
And then I have the
Nice.
quotation, you see it? You see the quotation?
Right.
Where I have such a duty of secrecy exists? On page
On 40,
Mhm. Or maybe it's a little, chapter
no,
5,
I see it.
okay, you see it?
No,
Page 41 in the book,
Okay, all right, minus
Oh.
4.
right?
I see
before
Vincent got his email.
Wonderful.
qualification.
Yeah, I received it. Thank you, Alan.
Okay.
No problem.
So you see the case of Parry Jones versus Law Society?
Yeah.
Okay, all right. And that's the quotation right there.
Okay.
Mhm. So in addition to this, preservation of confidentiality / duty of confidentiality, we also passed the Data Protection Act. And the part and why that Data Protection Act came out is because of computerization and the advent of the internet. Because with the impetus of the two of those things, it allowed for large amounts of personal information to be stored, accessed, processed, and transmitted with relative ease by both public and private institutions. And this potentially sensitive nature of personal information and the risk that an institution computer might be hacked or an electronic communication intercepted meant that there was a need for further clarity as to how institutions such as banks should handle, store, and transmit such information. And there's also a need for additional protection for those about whom such information was kept, such as the customer. So that's why I told you last week I wanted you to read the Data Protection Act, because the Data Protection Act sets out the responsibilities and the duties of the data controller. And the data controller in this case is the bank. So what the act actually does is it gives you the definition of what is data. It gives you the responsibility of the data controller. It speaks about the right of access and the exceptions to that right to access. And it also speaks to the duty of care that is owed by the data controller. So in addition to the Data Protection Act, remember when we did the first chapter and we looked at the legal framework and I highlighted or listed the cases that are relevant to banking law, I also spoke about the Computer Misuse Act. And that's because you have to put in appropriate measures against unauthorized or unlawful use of data and the accidental loss or damage. Personal data will only be processed fairly and lawfully if they follow the requirements under the Data Protection Act. Because remember, data should only be kept for a particular purpose and for a particular length of time.
Right.
So I really need you to read the Data Protection Act so you can understand whether you are talking from a bank, you're talking from a law office, you're talking from a medical office, you're talking from a government facility. They all have to comply with the Data Protection Act. It pertains to any company that has data on a person. Any questions on the Data Protection Act? So under Section 6 of the Data Protection Act, it says that a data controller, and a bank is a data controller, shall comply with the provisions in relation to personal data kept by him. The data or the information constituting the data shall have been collected by means which are both lawful and fair in the circumstances of the case. The data is accurate and, when necessary, kept up to date. The data shall be kept only for one or more specified and lawful purposes. It shall not be used or disclosed in any manner incompatible with that purpose or those purposes. So that means that you cannot keep a person's information for purposes other than that for which it was intended. It shall be adequate, relevant, and not excessive in relation to that purpose or those purposes. So you cannot go and add information to a client's file that's not relevant for the purpose for which you are collecting it. It shall not be kept for longer than is necessary for that purpose or those purposes, except in the case of personal data kept for either historical, statistical, or research purposes. So again, it depends on the purpose of the data and which regulator you fall under and the type of transaction that you're dealing with. There are time periods for retention of those documents. And under Section 8, it tells you that any individual who makes a written request to a data controller has a right within 40 days after complying with the provision of this section to be informed by the data controller whether the data kept on him include personal data relating to the individual. Notice what Section 8 says. That person has a right. They should be supplied with a copy of the information constituting any such data that the data controller holds in their name. And where any of the information is expressed in terms that are not intelligible to the average person without explanation, the information needs to be accompanied by an explanation. Then it goes in Section 9 and gives you the exceptions to the right of access. And it says that Section 8, which is the right to access, does not apply to personal data where it's kept for the purpose of preventing, detecting, or investigating an offense or breach of an agreement, apprehending or prosecuting offenders, or assessing or collecting any tax, duty, or any other monies owed or payable to the government. So you see how wide they did the Data Protection Act. Yes, you have a right to see the information as being held by a data controller. Yes, the data controller has to, by law, destroy your information unless it's keeping it for historical statistical purposes. But the law in Section 9 says that the data controller can divulge your information if there is a breach of an agreement, or you owe the Bahamas government taxes, or there's some statutory government body. Your information can be disclosed. Also, in a matter of national security, your information can be disclosed. So although a bank can owe a duty of confidentiality to a non-customer, if he gives an express undertaking to that effect, and this would be for, like, for example, if someone comes in with a business plan, they present it to the bank trying to get a loan. And a bank usually owes a duty of confidentiality to its customers as a result of a term implied in law under the banker-customer contract. So the leading case on confidentiality was in the case of Turnier versus National, Provincial, and Union Bank of England. In that case, the claimant, who was heavily overdrawn with the defendant bank, failed to meet the relevant branch manager's repayments demands. When the branch manager noticed that a check drawn on the account of another customer at a different branch and payable to the claimant's order had been endorsed to a bookmaker by the claimant and was being collected for that person's account, he telephoned the claimant's employers, ostensibly to ascertain the claimant's private address. During the course of the conversation, the manager disclosed that the claimant's account was overdrawn and that he had been dealing with bookmakers. The claimant's employers subsequently declined to renew the claimant's contract upon its expiration. And the Court of Appeal held that the bank had breached its duty of confidentiality and awarded damages to the customer. In reaching the conclusion, it was critical for the court to decide whether the bank's duty of confidentiality extended to information received by the bank from sources other than the customer himself or from his account. Since the information that the bank manager disclosed in Turnier was not acquired from operating the claimant's account, but rather from the checking operations conducted on the drawer's account. One of the judges rejected the view that the duty of non-disclosure is confined to information derived from the customer himself or from his account. But what he said was that it extended to any information, regardless of its source, that was acquired in the character of banker. Another judge held that the bank's duty of confidentiality was not restricted to information about the actual state of the customer's account, such as the amount of the debit or credit balance, or information derived from the account itself, such as looking at the transactions, but also encompass information obtained from other sources than the customer's actual account, if the occasion upon which the information was obtained arose out of the banking relations of the bank and its customers. One of the judges, of course, expressed a contrary view, and he said that holding that the bank's duty to respect its customers' confidences did not apply to knowledge derived from other sources during the continuance of the relation. Of course, on this point, the court subsequently preferred the majority view in Turnier. And even in the most recent case in Barclays Bank versus Taylor, the judge said that the banker-customer relationship imposes upon the bank a duty of confidentiality in relation to information concerning its customer and his affairs, which it acquires in the character of his banker. Any questions? That is the leading case on confidentiality in general, that duty. Turnier versus National Provincial and Union Bank of England. Now you heard the way in which the judges decided that it's not just the way how he's operating the account, but you could get information outside of that. And by relaying that information, you can breach your duty of confidentiality. So even though it is recognized that information is only covered by the bank's duty of confidentiality when it's acquired in its capacity as banker, that would suggest that the information acquired before the commencement of the banker-customer relationship mean like before the account is open, would fall outside of the scope of the duty. And that information received after its termination would similarly be excluded. But nevertheless, there are good reasons why banks still need to exercise caution in these circumstances. Information received by the bank before the banker-customer relationship commences may subsequently be repeated by the customer and may fall within that duty. And secondly, information may be passed to the bank at any time in circumstances that's subjected to the general law of confidence. And thirdly, the bank may be given an express undertaking to the customer to keep particular information secret, even if it falls outside the scope of the bank's implied duty of confidentiality. And fourth, as stated in Turnier, the bank's duty of confidentiality in respect of information acquired during the course of the banker-customer relationship does not cease when that relationship is terminated, but rather it extends beyond the period when the account is closed or ceases to be an active account. So as in the case of Turnier, the judge said that the bank's duty of confidentiality does not cease the moment a customer closes his account, but that information gained during the currency of the account remains confidential until released under circumstances bringing the case within one of the classes of qualifications that he referred to. And this duty probably even continues after the customer's death. So the bank's duty of confidentiality, prima facie, covers all information acquired by a bank in that capacity. And if a matter is taken to court, what they try to do is you try to use common sense. And what they'll do is exclude certain information that the judge feels is not relevant. In the case of Christophe versus Barclays Bank, the customer's husband, he had transferred the matrimonial home into her name before he was adjudicated as bankrupt. The husband's trustee in bankruptcy registered a caution against the property, but this was subsequently canceled. So despite the husband who was acting as his wife's agent, specifically instructing the bank not to disclose that the caution had been canceled, the bank nevertheless informed the husband's trustee in bankruptcy of the fact in response to the trustee's request for information. So the trustee accordingly re-registered its caution. The customer claimed that the defendant bank had breached its duty of confidentiality, but the Court of Appeal, affirming the decision of Lord Collins, struck out the claim as disclosing no cause of action. The principal reason for this conclusion related to the statutory regime for registration and cancellation of cautions, pursuant to which cancellation of a caution would only occur once the cautioner had received notice from the land registry. So as the trustee in bankruptcy must have been informed previously of the caution's cancellation, the bank could not have breached its implied duty of confidentiality by revealing information to someone deemed to have that information already under the statutory regime. So it said that because the bank should have been aware that the caution had expired or canceled and that it then had to be re-registered by the bank informing him of this, that was not a breach of confidentiality. Now, there would have been a breach of the bank's duty of confidentiality if the bank had expressly undertaken not to reveal the information to the trustee in bankruptcy, or if they had revealed the information in that case to a person who did not have a statutory right to receive it. Any questions so far? Yes, no? So when you speak about the duty of confidentiality, in the Turnier case, Lord Justice Banks identified that there are 4 situations in which the bank owed no duty of confidentiality at all. One is where disclosures under compulsion of law. 2, where there is a duty to the public to disclose. 3, where the interests of the bank require disclosure. And 4, where the disclosure is made by express or implied consent of the customer. Now, Ellen read section 77. Can you tie in these 4 exceptions in section 77? Do you see where the Bahamas has enshrined these within section 77, these 4 exceptions? Who can tell me where's the first one? Disclosure under compulsion of law. What's the subsection under section 77 that speaks to that?
Would that be 7?
That sounds like just about, and we spoke about the FIU, correct?
Right.
Okay.
Right, that's it.
Okay. And where there's a duty to the public to disclose?
You say where there's a duty for the public to disclose?
Hmm?
You say where there's a duty for the public to disclose?
That is an exception. Let me leave that one for now. Until I explain that one to you, and you can see if you can tie it in. The third one is where the interests of the bank require disclosure.
That's fine. Yes, only fine.
I'll come back to that one.
That's B.
That is in
That's B?
subsection 7B.
B.
Credit rating.
Yeah, that's B.
And you said which one is that? The second one or the third one?
The third one.
Where the interests of the bank require disclosure.
Yeah, the third one.
The third one.
Okay, write it down on yours. We coming back. I'm gonna explain the third one to you. And then the fourth one, express or implied consent of the customer. I know you could find that one. Yes.
That's F.
F, yes.
1F.
1F.
77, 1F.
All right, so let's start with the first exception. compulsion of law. The most common example is usually involving regulatory or investigatory authorities being allowed to access the confidential information held by a bank about its customer. So sometimes it could be the police. A bank can sometimes be ordered by the tax authority to supply information concerning its customers. So if there is an investigation going on, of course, you know, the police or the Attorney General's office can make a request to the bank to provide information. So that's under compulsion of law. And whenever you speak about compulsion of law, there are significant pieces of legislation that curtail that bank's duty of confidentiality. And what are those legislation? First exception to the banker's duty of confidentiality is compulsion of law. And I'm saying to you, there are significant pieces of legislation that curtails the bank's duty of confidentiality. Meaning that there are legislation that they are compelled by law to disclose a client's information. What are those pieces of legislation? Anybody knows?
Would it be like for tax purposes? Something like that?
Yeah, but what's the legislation? I gave you an example of tax already.
Repeat
now-
that again, Ms. Acha.
Okay, so listen to what I said. I said the first exception to that duty of confidentiality is when it's by compulsion of law.
Mhm.
And I say this normally involve regulatory or investigatory authorities.
Right.
They're allowed to have access to confidential information held by a bank about its customer. And I said, it could sometimes could be the police. It could be the Attorney General's office.
Mhm.
And I said also a bank can sometimes be ordered by the tax authorities to supply information concerning its customers. And then I said, one of the most significant example of legislation that curtails a bank's duty of confidentiality is what? What legislation curtails the bank's duty of confidentiality? Unit 1.
Oh, I understand it now.
Getting it?
The light
Mhm.
just come on.
Okay. Thank God the light is on. I'm no longer in that.
Yeah, yeah. Okay. Okay.
Where are your colleagues? Let's go. Capron, Charlton. What is the legislation that curtails the bank's duty of confidentiality? Hmm? Okay, so the legislation that curtails the bank's duty of confidentiality is the Proceeds of Crime Act. The Terrorism Act.
There,
Am I not correct?
there's. Remember the question when I was asking you, when you say that was the criminal part of it?
Yes.
Yeah.
Mhm. So compulsion of law. So yes, the bank has a duty of confidentiality, but those two pieces of legislation, yes, the duty of confidentiality is not relevant when it comes to requests under the Proceeds of Crime Act and the Terrorism Act. Because you're required by law to disclose to the relevant authorities your knowledge or suspicion that a customer could be involved in money laundering or terrorist activity. But on the opposite side of this, it is a protected disclosure because the bank is protected from liability for breach of its duty of confidentiality. Now, sometimes if you have legal proceedings against a customer, sometimes there are legal ways to disclose a customer's confidential information. A bank cannot refuse to answer questions concerning its relationship with a customer, stating that they can't do it on the ground of privilege. Means that everything between them and their customer is secret. And so what the courts will do is they will actually send an order, what we call a Norwich Pharmacal order, Norwich, Norwich Pharmacal, Pharmacal order. And that compels the bank.
Sorry, Ms.
make-
Audra, can you spell that again, please? Sorry about that.
Norwich,
Yes, ma'am.
Norwich, one word, next word, Pharmacal, order, ORDER.
Okay, thank you.
Okay, so the bank will be compelled to make pre-action disclosure of a customer's confidential information to a third party. And they do that so that that information will be used to assist commencing a proceeding against that customer. And this order is only granted if 3 conditions are met. 1, there have to be an arguable, I guess it has to be at least arguable that a wrong has been committed. At least it has to be arguable that a wrong has been committed. Second, there must be the need for an order. There must be a need for the order to enable action. There must be the need for an order to enable action to be brought against the wrongdoer. And the third is the person against whom the Norwich Pharmacal order is sought, the person against whom the Norwich Pharmacal order is sought must be so mixed up in the acts of the wrongdoer must be so mixed up in the acts of the wrongdoer as to have facilitated the wrongdoing. And be likely to provide the information necessary for that wrongdoer to be sued. Now, in some cases, sometimes the bank may be innocently mixed up in all of this. And that happens because sometimes the funds could be proceeds of fraud and the funds pass through the bank. And then many other cases I could go on and on under compulsion of law. But I won't work you that hard. The duty to the public. Now, in most cases, this second exception is described as the least easily comprehended of the 4 exceptions. And this is because the circumstances in which the public interest requires a person to disclose confidential information and the nature of the information that may be justifiably disclosed are not static or immutable. So for example, in Turnier, Lord Justice Banks doubted that a bank was entitled to disclose information concerning its customer to police officers who were investigating that person for a series of frauds. Whereas more recently, it has been recognized that the duty to investigate and deal with criminal conduct is a higher duty in the public interest than the banker customer confidentiality. So it's difficult defining the scope of the second exception. And it has been a lot of discussions on this whole second exception. So in the case of Price Waterhouse versus BCCI Holdings, Luxembourg, Judge Millett confirmed that the second Turnier qualification provided an independent ground for justifying disclosure of confidential information. So according to his lordship, such countervailing public interest was not limited to the interest in detecting or preventing wrongdoing, but it included the interest that exists in ensuring the effective regulation and supervision of authorized banking institutions, such as the protection of depositors. Millett J. concluded that just as the public interest required confidential information to be disclosed to the regulatory authority, such as the Bank of England, to enable it to carry out its statutory functions. So there was at least as great a public interest in the disclosure of such information as part of the investigation into the Bank of England's past performance of its statutory functions. So if I go back to section 77, which one speaks to the second exception? duty to the public? Which one speaks to the regulatory bodies carrying out their statutory duties? Anybody?
Section 6.
Yes, ma'am. You know this is on the exam, right? Okay, the bank's own interest. Again, Antonio, Lord Justice Banks said that the bank's duty of confidentiality is also qualified where the interests of the bank require disclosure. Now, this qualification will cover the situation where a bank commences proceedings against its customer to recover an unpaid loan or an overdraft facility. And the bank has to disclose in the pleadings the extent of the customer's liabilities. Although the qualification will not necessarily cover such disclosure where the proceedings are commenced by a different member of the same banking group, or where the bank reveals confidential information in circumstances where its interests conflict with those of its customer. So who could give me a good example of the third exception where the bank is disclosing confidential information because of its own interest? Who could give me an example of that?
Say that again, where the bank is disclosing information for their own interest.
Yes, that's the third exception, the bank's own interests.
And the bank is disclosing this information on the customer.
Yes.
And this is legal.
And it is legal, yes.
Okay, so I would say an example would be it in terms of the credit bureau. I'm not sure well, you should be aware of the credit bureau. Where the bank would disclose customer information on the report. However, it wouldn't be in detail in terms of which bank and which bank the facilities are from, but the information from each bank in terms of liabilities would be on the credit bureau report. That's an example.
Okay, another one.
In terms of when bank would give customers liability information, I would say in terms of in court, if that's something that needs to be addressed from a legal standpoint.
You're correct.
And the court is requesting those information, then the bank would have to give out that information.
Correct.
I mean, the bank would have to give the court that information. Yes, ma'am.
You're correct. What section it falls under? What subsection in section 77?
With subsection? Oh boy, you got me down.
You could get help. There's others on.
Can anyone assist me? What subsection is that?
1F.
1F.
I think that's F.
Yes, it is. It is F.
Okay.
So a less obvious example of a defensive disclosure arose in the case of Sunderland versus Barclays Bank. And that's where the defendant bank dishonored the claimant's check, primarily due to the account having insufficient funds, but also due to the bank's knowledge that the checks were drawn in respect of gambling debts. During a telephone conversation between the branch manager and the claimant's husband interceded at her request and was informed that most of his wife's checks were drawn in favor of bookmakers. Dismissing the claim against the bank for breaching its duty of confidentiality, Lord Justice Duparc held that the bank's disclosure was not only justified in its own interest, but was also justified by the wife's implied consent to the disclosure to her husband. Whilst it may be doubted whether the wife's complaint to the bank about it dishonoring her checks indicated her implied consent to disclosure being made to her husband, the unjustified nature of that complaint meant that the bank had an interest in defending its reputation by informing the husband that it had valid reasons, namely the insufficiency of funds in his wife's account for refusing to honor her checks. Given the disclosure of the account's inadequate funds was sufficient to defend the bank's reputation. However, it is more difficult to understand why it was also justified in revealing the wife's gambling activities. So despite the suggestions of a leading commentator, the criticism of Sunderland's case was that once the banker's duty of confidentiality is located within the general law relating to breach of confidence, disclosure should only ever be justified in the public interest and never in the bank's own private interests. The existence of the third tenure qualification has been confirmed in subsequent authority. Nevertheless, there seems to be a general recognition of the importance of keeping the scope of this qualification within a fairly narrow confine. So the third one is not a wide exception in the bank's own interests. The courts normally rule in a very narrow, very narrow confine. Because other than that, then the banks can abuse it. The fourth exception is information disclosed with the customer's authority. What section is that? You say one?
Once. That's 1F.
1F, again. So in the case of Turnier, Lord, banks again recognize that the disclosure of confidential information by a bank was permitted where the disclosure is made by the express or implied consent of the customer. Establishing the existence of a customer express consent is largely a factual question, and its scope depends upon whether the customer consented to disclosure generally or whether the consent was limited to a particular occasion or particular information. Obviously, customers do not consent to the bank providing inaccurate information. That's where the part about the credit bureau comes in. Remember, whenever you give information, it has to be accurate information. So customers do not consent to the bank providing inaccurate information about them. Again, if you go to the Data Protection Act, what does it say? You have to keep your data subjects information updated. And it must be retained for the purpose for which it was intended. And it cannot be retained longer than the retention period. So again, customers do not consent to the bank providing inaccurate information about them. And a bank should decline to disclose its customers' information if it has reason to believe that the customer's apparent consent was the result of compulsion, such as when disclosure is compelled by the order of a foreign court. There's more difficulty, however, it lies in identifying the circumstances when the customer's consent will be implied. In Turnier, Lord Justice Banks gave an example of a situation falling within his third qualification, the familiar instance, where the customer authorizes a reference to his banker. And Lord Justice Atkins similarly considered that the justification for disclosing confidential information in a banker's reference must be upon the basis of an implied consent of the customer. Adopting this approach, banks for many years relied upon the existence of a general banking usage, whereby customers impliedly consented upon the opening of their accounts to any disclosures necessary to respond to a status inquiry. Indeed, it is maybe not unreasonable to assume when a customer is asked to supply the name of a referee or his bank when applying for such facilities as a credit card, that he is impliedly consenting to the disclosure of any necessary information by his bank. And you agree to that, right? That's implied. So allowing a bank to rely on a customer's general consent must be that the bank bears the burden of ensuring that the customer is aware of the way in which the bank's reference system operates. And finally, although Turner certainly improves the customer's chances of establishing liability against a bank for breaching its duty of confidentiality by responding to a reference request without first obtaining the customer's consent, such a customer may continue to experience difficulty recovering substantial damages in respect of that breach, because it is an implied consent. So whilst general damages will usually be available, special damages may sometimes be difficult to recover. If the bank discloses accurate information that is favorable to the customer is unlikely to suffer any adverse consequences resulting in loss, even though that is not an absolute rule. If the information is accurate but unfavorable, the customer may have difficulty showing that the bank's failure to obtain his consent caused his losses. The only situation where special damages are likely to be readily recoverable is where the information supplied by the customer's bank proves to be inaccurate, although in such a case, the customer will also have a concurrent claim based upon the breach of the bank's duty of skill and care. And remember, we spoke about skill and care when we discuss the duties of the bank. And that's why you're doing this class, because the bank can be sued if it breaches its duty of skill and care. Any questions? Everybody is so quiet.
And I mean, based on what you explained, it's not, it was clear. So no, I don't have any questions in regards to that.
Very good. So, like I said earlier, the midterm goes from chapter 1 to 5.
So my question is, right, like
Yes.
how when you asked, how you was asking questions in regards to the information, we would have to indicate in our answer what act that information is from, because I know you was asking which act and which section was the answer from.
Mm-hmm.
You
Well,
have the reference act or the section.
okay, so let me explain to you. When you're doing a question on confidentiality, I expect you to know section 77.
Okay.
I don't expect you to know section 77, subsection 7.
You don't expect us to know that?
No, I don't expect you to know 765 for the numbers.
Okay.
And no. But I expect you, if you are speaking about the 4 exceptions, to be able to say to me that section 77 includes 4 exceptions.
Okay,
then,
so we can speak basically. Sorry.
Exceptions using cases.
Okay. Okay, then. So we use the section, so not the exact section or act.
Not the subsection. No.
Okay, not the subsection. Okay, understood.
So if you read the Data Protection Act, the same I said section 7, 8, 9, and 10. I don't expect you to give me all of those for data protection.
Okay,
A confidentiality, yes. This is what you do. But data protection, you just need to know what's required by law. You have to keep the information accurate. Keep it for the purpose intended. Cannot go beyond the retention period. And then you should know the exceptions. The same way there are exceptions under confidentiality, there are exceptions when a data controller must release information. So I don't expect you for the Data Protection Act to be able to give me those sections. Where the section 8, 9, 10, 12, 13, no. But you have to know the general idea of what the Data Protection Act is about and tie it into your duty of confidentiality.
okay, and then you also said that the midterm is gonna be on section 1 through 5, correct? Hello?
Yes, 1 through 5, correct.
All right. And then the Data Protection Act also. So is there any other acts we need to take into?
All those from
No.
chapter,
All those from chapter 1 through 5, okay.
no, yeah. But chapter 1 gave you the legal framework. Remember? It spoke about the Central Bank Act, the Banks and Trust Companies Regulations Act, Proceeds of Crime Act, Anti-Terrorism Act, Financial Transaction Reporting Act, Data Protection Act, all those are there. The only ones you will not see in your midterm are the ones relating to money laundering, proceeds of crime, because we haven't covered that chapter yet. That's coming. So you could eliminate those that deal with money laundering. But you will remember when we did compulsion of law, which is one exception to the duty of confidentiality. And I asked you, what are the laws that curtail that duty? Remember? And I said the
Yeah.
laws, right? That is the Proceeds of Crime Act and Terrorism. And that's all you need to state on that. When we get to the other chapters and we do money laundering, then when you do the final exam is when you will spill your guts as to what's required. Any other questions? No? All right, so you need to catch up on your reading. Next week, we will do chapter 6, where we're going to talk about different types of customers.
So no review, we just going straight to chapter 6.
It's not time for midterm yet.
Midterm week after next, right?
We agreed with when is it?
I thought it's November 1st.
Something like, I can't remember the date. We
Yeah,
agreed.
November 1st.
Yeah,
No,
November
hold
1st,
on,
a bit
hold on.
close.
Hold on, I just catch what she said. What's the word you use?
Review.
We just finished it yesterday.
I mean, because you said the midterm is going to be on chapter 1 through 5, but we going over chapter 6 next week too.
Well, yeah, we finished with that now. There's no review.
Okay, so technically
Okay.
we should be studying 1 through 5, but then we're moving on
Yes.
to 1 through 6. So, okay.
Yeah.
And but chapter 6 wouldn't be
On
that would be on
exam.
the
Oh,
final.
say that again?
Chapter 6 wouldn't be on the exam.
No.
Okay.
Chapter 6 is not on the exam. 7 is not on the exam. No. So what should be in this review now? Let me hear this voice before you all go home to start studying.
I guess all content as it relates from chapters 1 to 5.
I would say questions questions pertaining to 1 to 5, so we could have an understanding on how the exam would be.
You just had 2 homework questions.
Yeah, but I don't think the whole exam is going to be based on those questions. The whole exam is going to be
Have
just,
some multiple choice. You forget you'll ask for multiple choice.
yeah.
You're gonna have some
mean-
multiple choice and some scenario questions. And you're
Okay,
gonna have
so-
contract question.
Okay, so scenario choice, multiple question, and contract questions. So we could, is it okay? Can we review another, I would say another contract question along with the next question as a group? As a scenario question as a group?
What do you mean as a group? Like how we did it today?
Yeah,
Yeah. You want me to send you all a contract question and a banking question?
yes, ma'am. And then we could have a overall conversation, but it as a group next class.
Yes, but please don't send it in the day.
Say again, please don't.
Don't send it to me on the day. Russell know what I mean.
Yeah, I know. You sent it the day before.
Yeah, send it at least the day before. Don't send it
Okay.
10
I
minutes
know.
before class
So
start.
with the assignment
Okay.
that we did, are we gonna get well, I know you said they did feedback in class, but are we gonna get a grade on it?
Yes, I add points to your midterm.
Are we gonna know the points before the midterm?
I could, but if you do that, you'll be hindering yourself. I like to see what your grades are.
Okay, understood.
Yeah,
All right.
yeah. Because then I could decide whether I'm just giving them each homework 2 points, or I could decide that I'm giving the homework 3 points, or I could decide I'm giving it 5. Depends on what the grades look like and where you fall weak.
Okay. And how much percentage is the midterm again? Trying to remember. I think that's what, 20%, 30%?
30%.
Okay, 30.
Yes. Okay. So you want me to send 2 questions?
Ms. Archer,
Go ahead.
the contract questions, those would be like the first set of questions we had for homework, right? With the minor and the
Yes.
different scenarios. Okay.
Yeah. I'll send you one of those. So I'll send you someone buying something or someone doing something. I'll do that. And then I'll send you a banking law question, which you all did very well this time. So let me say you approach something else. Okay? There's no
Okay.
need to be frightened. You
I
all
hope
did
so.
homework. Of course, I know the homework, you had the book open. But this time you won't have a book. Yeah. You got to go by memory. Okay? So I don't know if you want to look at the question, then look at the chapter, or just take the question and just put a note on top of your answer and say, I answered without the aid of my book. Just don't forget you get a point for attempting. So let's say if I decide at the end, looking at the grades, I decide that, okay, every homework done was worth 3 points. You may have been wrong, but you did it. You still get your 3 points.
Okay, so we could do that for this exam, this
You
question
can do
is sending out.
Yeah, you could do it without looking in your book.
Okay.
So you could see if you really understand it and where you fall down and what you really need to focus on for
Okay.
that kind of question. It's up to you. But I
Okay.
wouldn't say keep looking in your book and answering, because it's not going to help you.
Understood.
Yeah. So just do your best and just do it just from what you know. And we could go from there. All right. And that goes for everybody. I think it'll help you if you can write it without having to look in a book. Okay.
Okay.
All right. And those who haven't read Maurice Clinton, please read it. Those who haven't read the Data Protection Act, please read it. You need it for the midterm. And if you haven't read Section 77, you need to read it. Okay?
Okay.
All right. So what I'll do is, I'll see. If I have the time, I'll send these cases now, but I don't want to confuse you. Like, I don't want you to panic. So I'll see if I'll send these other cases to you. Just so you could have it, and so I won't forget that I didn't send it. So I'll see if I'll send these to you all before the week is out. But you don't need these for the midterm exam. Okay?
Okay.
All right. So have a good evening. Start studying. And when I send the questions, then you make all the attempts to answer.
Okay. So what I'll do, I'll review my work first, and then I'll attempt it without looking in the book after.
Agreed. That's fine.
Okay.
Yeah.
Okay.
And you can just put on the top of your
Right.
just put answered closed book.
Okay.
Yeah. And then I know that you tried it without looking in the book. So I know it's not a verbatim thing.
Okay.
Okay, that's fine.
That's fine. All righty. Enjoy the rest of your night.
Okay, you too. Good night, everybody.
Good night.
Good night. Next
night.
week. Good night. Night.
Ms. Archer,
Yes, my dear.
I don't think that you ran over my paper with me.
Hold on. Where did I put the papers? That's Nadia, right?
Yes, ma'am.
Yeah, I have your paper. You came in late, eh?
Yeah, about 15
That's why.
minutes.
Yeah, I put yours on the side. I did everybody else's but yours. So hold on. I need to see where I put them. Oh, I put them up here. Because I have the points. Okay, here we go. So I looked at yours. You had who has the bank damage, Mr. Williams credit. Because they overlooked a stop causing a check to be returned. That's only one issue. There were 3 issues. So you have to state the 3 issues. So what were the 3 issues? 1 was the way in which he was managing the account unsatisfactorily. You have to talk about that. Second is the stop payment. And the third one is complaint about his reputation.
Okay.
So when you start your analysis, so your issues, you only had 1 and there were actually 3. So your first paragraph is fine. You spoke about Jahimson versus Swiss. Of course, you're talking about the duties. That was okay.
Okay.
Next day, however, there's a practice for Williams to issue checks with the insufficient funds. So in your second paragraph, you now beginning to address the first issue, but you never made that issue when you started, but that's fine.
Okay.
So you're going in the right direction.
Okay.
Said, nevertheless, the bank continued relationship, and that's a very good point.
Okay.
Because he was not operating the account in the right manner, but they continued. And
Okay.
because they continued, that is why they have to now apologize for not following his instructions
Okay.
and why he thinks he has a claim
Okay.
because of his reputation.
Okay.
So, like I told the others, if he has his normal procedure is to keep stop payment on checks. He doesn't have a good reputation out there with the people he does business with.
Right.
It's the flip side of it. So the question really, are we damaging his reputation, a reputation that is already bad?
Okay.
Then you gave the case of Westminster versus Hilton, which was good.
Okay.
Then you say, on the other hand, the bank can argue that Mr. Williams should not have frequented a stop, which is good again, because I have a tick here.
Okay.
And you say also that the stop payment would only be requested for loss or missing check, which is fine. But you didn't add in that going back to the very beginning.
Mm-hmm.
So you missed out that he really can't claim for bad for reputational risk because he already has a bad reputation. Based on
Okay.
the manner in which he's operating the account. But secondly is, at the end of the day, knowing how he operates his account, the bank should terminate his relationship or monitor it for 3 months to see if he's still going to be doing this kiting and make a
Okay.
decision to close his account.
Okay.
Remember, the bank is all about risk. They should not be keeping and taking this risk
Okay.
because that's kiting.
Okay. So order the 5 points. How much would you give this homework for me?
Oh, what I was saying is depends on the midterm grades. I could decide that every homework is worth 5 points. Or I could decide every homework is worth 3 points.
Okay.
Right. So it depends on the grade because I may have someone who passed the midterm with 90.
Mm-hmm.
And then when I add on their grades, they would come to 100.
Okay.
So I would be roughly looking at 10 points. So that'll be the maximum I could give anybody for all of the homework that you did. So everything depends.
Okay.
So let's
Would
say if the highest grade is 85, that
Mm-hmm.
means that I have 15 points to play with homework.
Straight across the board.
Yeah.
Okay.
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 But there was nothing wrong with your answer except that you didn't write out the issues and that's why you missed some points. So when you do the 2 that I send you to do now for next week,
Mhm.
make sure to write out your issues.
Okay.
That's the only way you'll try not to miss any points.
Okay, so like the same way I list the facts, this list the issues or this.
Uh-huh. So you
Okay.
did put on the issues, you only put 1 issue, but there were 3.
Okay.
Yeah.
So with the questions that you normally send, would there always be 3 issues or more or
No.
less?
No, that could be 1 issue, could be 2, could be 3, could be 4, could be 5.
Oh,
Yeah. Then they're not the same numbers.
okay.
Yeah.
Thank you.
All right, not a problem.
Good night.
Okay, good night, my dear.